Hello, everyone. How are you doing? This is Greg Lake with MrMaritimeLaw.com coming at you with my second video today. First off, I'd like to take a time to thank everyone who's come out and showed support, like the YouTube channel. Please subscribe to the YouTube channel. Thank you for visiting the website, and thank you for supporting all of our other social media. It definitely helps to keep me motivated to keep generating this content, as I see it reaches more people and hopefully the seamen that it's intended, to reach. Definitely keeps me motivated to come back every day and write these articles and continue to make these videos. So today's video is going to be about why Jones Act seamen, why it's necessary for Jones Act seamen to acquire both competent and resource-rich counsel to assert their claims under the Jones Act. Now, as I mentioned in the article, it kind of goes without saying that anytime you're asserting or defending claims in court, everyone both deserves and has a right to competent legal counsel. So that goes without saying. But I want to take a time to talk about this in context of Jones Act claims for special reasons. And, because these claims tend to be so valuable, because the damages tend to be so great, you just want to make sure that you get a lawyer who's competent, resource-rich, and really in it for the right reasons to make sure that they don't leave a stone unturned, which we will discuss, when litigating your claim. So first off, let's start to talk about why Jones Act claims are substantial, and that discussion necessarily entails what are the different damage categories generally available to Jones Act seamen. So first, we have past and future medical expenses. And as I'll discuss in just a little bit, injuries that occur aboard vessels in navigation tend to be more severe than other personal injuries. That's not to, discredit anyone else's injuries. It's just to say that the nature of the work on the water on a vessel tends to create situations where injuries sustained tend to be more severe. So with that, your past medicals and future medicals are going to be expensive. I've never seen a Jones Act claim, again, in my short career, admittedly, but I've never seen an injury that occurred upon water on a vessel that was soft tissue in nature. And again, I mentioned this in the article that, many car wrecks and other types of your run-of-the-mill personal injury cases a lot of times involve soft tissue injuries, and that's not to downplay soft tissue injuries. They can affect a person's life and quality of life and definitely need medical treatment. But for the most part, the injuries I've seen from Jones Act seamen working on the water tend to be, hard injuries in the sense that, broken back, missing fingers, things of that nature that definitely require significant medical attention, both, past and future. So that's one of the damage categories. The second one, past and future pain and suffering, which kind of coincides with the first, right? The more severe the injuries, it can be more or less inferred that the more pain and suffering that has been suffered. Past lost wages. So, working on the water, people make really good money, and rightfully so. You're working in such a dangerous but very important and critical field, that wages tend to be, higher. So that's also another damage element that lends itself to being higher in Jones Act cases. Loss of future earning capacity. And I'll say this, I will do another video that kind of breaks down each of these damage elements and kind of gets more specific into what each one entails. But, the loss of future earning capacity really concerns, now before my injury, I was working making this kind of wage. Now, because of my injuries in the future, and the lack of physical capability that I once had, now my wage earning capacity is this. So, there's this gap. So theoretically, the employer would be, or whoever the defendant is in the Jones Act case, would be liable for that gap through the work life of the injured party. And again, this will require more times than not expert testimony to establish those numbers and to establish the work life of the particular claimant. Okay. And then last, maintenance and cure damages, which are, just by virtue of getting hurt working on the water aboard a vessel, Jones Act seamen are entitled to maintenance and cure. Now, and we will get into this very deep through the content here on the website, but, there are instances where, seamen are denied maintenance and cure when they're rightfully owed. And if the certain degree of culpability is present on behalf of the employer, could possibly entitle the seaman to punitive damages, which also increases potentially the value of these claims. And again, let me go back and again harp on the fact that injuries, on the water tend to be severe, and due to their severity tend to affect the lives of these seamen well into the future, perhaps for the rest of their life, right? And so, and that also affects their family and others that love and care for them. So these things last way beyond the injury. And so all of those damages need to be fairly calculated and asserted in a Jones Act claim. So when we talk about competent counsel, now, maritime law generally isn't super niche of an area of law, but when we kind of, even within that category has other subcategories and kind of narrow it down for our purposes to Jones Act claims, is a pretty niche area of law. And again, to be honest with you, I had no idea about, this specific niche of law until I just ended up working with another lawyer in Baton Rouge doing these claims, which granted, I love it and very fortunate and happy to have been able to be a part of that. It's now my academic and professional interest to research and write about these topics. But again, there's just not a ton of lawyers that actively litigate Jones Act claim. And that's not to say that there might be lawyers out there who've never litigated a Jones Act claim that might absolutely be competent enough to pick it up first time and hit a home run. Don't get me wrong. But it is a super niche area of law. And so trying to pick an attorney with the appropriate amount of expertise and experience can be challenging. Not impossible, but it can be challenging if you're not familiar with the territory, right? So now let's kind of shift and talk about what to most definitely avoid in a lawyer when you're seeking counsel for a Jones Act claim. And I say this in the article, and that's any talk of quick settlement should more than likely be avoided, meaning that you should probably move on and go seek counsel elsewhere. And this is why I say that. Are there probably cases out there where the defendant or the employer just comes out of the box and makes an absolutely great offer that leaves no doubt in everyone's mind that it is fair compensation for the seaman? I know it's happened, and I know it can happen. But from my experience, I can tell you that that's going to be a rarity. And again, going back to all these different damage categories, right? Discovering the nature and extent of damages doesn't occur overnight, right? I mean, calculating the future, lost future earning capacity, calculating lost wages, and really as it relates to medical, because when the injury happens, really is kind of the start of the medical treatment, right? So these things evolve over years. The doctor might not be able to say until 2 years down the line what exactly future medical will be required. So again, these things take time. And so if we're talking about quick settlement, more likely than not, that's not accounting for all the different variables that affect these damage categories that I mentioned. In the article, I mentioned a story that, personally occurred to me. I had brought in a 19-year-old client who was working on the water. I think it was his second hitch, lost 2 fingers on his dominant left hand, right? Very sad, unfortunate situation. The kid and his mother, both very nice people. It was an honor to be involved in representing him. But she relayed to me that before they found me and another lawyer I was working for, they had actually spoke with another lawyer. And that lawyer mentioned first meeting that he thought he could settle the case. And this is just a number I can't remember exactly. But I want to say it was like $600,000 or something like that. Like we can get this settled in a week, $600K. And the mother, who was obviously helping her son, choose the proper counsel and help him properly assert his claim, knew right then that, that's not calculating for all of her son's potential loss damages, which would need to be calculated before, any real settlement could be reached. So, not to say that lawyer was out of bounds. I don't know the facts he had in front of him at the time or what, or whoever it was. But obviously in that case, a quick $600,000 settlement wasn't appropriate considering the circumstances. So that's why I relay that, because look, a quick payday for everybody, we all like that, right? The quicker the money, the better the money. But as with all things in life, what comes quick, what comes easy isn't necessarily the good or right or equitable thing. So look out for that. Now let's switch over. So what should you look for when you're trying to acquire counsel to assert your Jones Act claim? Well, these Jones Act claims are very expert driven. What do I mean by that? Well, everything from liability to future lost wages, to past future medical, pretty much all the damage items that I mentioned in the article require expert testimony to what we call prove up in court, right? To establish with the court that, in fact, this is the case. And trust me, with the amount of money on the line, usually in Jones Act claims, the employer is going to throw significant resources at both hiring lawyers and hiring experts to controvert, the seaman's claims. So what does that mean? Well, it means that any plaintiff's lawyer who is representing a Jones Act seaman needs to be discussing how they're going to hire experts, what they believe at that time they're going to hire experts for, in order to prove up your claim and overcome, whatever's thrown out there by the defense. So it's very key, right? And this kind of relates to the last thing I'm going to mention, is that you want counsel that's resource rich. Now, I don't say that to say that, if it's not a huge law firm with 50 attorneys, that they're not capable of litigating these claims. As a matter of fact, in my experience, some of the smaller, more maritime focused firms are actually some of the more resource rich. And again, the reason why you want a resource rich counsel, because look, because of the amount of money on the line, a lot of times expenses get high. Everything from filing fees to deposition fees, all the way to, and I'll discuss this in a minute, possible advances. And also, a lot of times when there's a denial of cure, it's up to the plaintiff's attorney to go out there and get surgeons and doctors to treat their client, right? So they have to have some type of credibility with these medical institutions, to help get their client in to get the appropriate medical care, right? So a lot hinges on the resource richness of counsel. And so, can you just go in and be like, hey, what kind of credit line do you have? Or what kind, you're probably not going to get that information, but definitely be asking the lawyer, do you believe you have enough money on hand or credit on hand to fully assert my claim? I have seen expenses in maritime cases get in excess of $100K. So, it's very important to make sure from the beginning that the plan is, and the ability of the lawyer is, to have enough resources to fully litigate the claim. So that's my spiel on this. Again, I will continue. There'll be a lot of videos coming based upon the information in this article. One of the main ones that I want to do is break down these different damage categories and explain them in depth. So that way you can kind of get an idea of what we're looking at for these different damage categories. But anyways, I want to thank everybody for coming by, stopping by. Please like, comment, subscribe on the video, visit our social media, visit the website. Again, all the support really helps to keep me motivated and keep getting this content out. As always, if you have any questions, comments, concerns, or want to discuss the content of this video, this article, or any other video or article, please feel free to email me at glake@mrmaritimelaw.com, and I'll be glad to set up a time to talk. With that, everyone, have a good day.